Hello, Your Honour, and thank you for allowing this video recording to be admitted to you today. It is very much appreciated. Now, as you're aware, my client has been charged with 5 counts of breaking and entering premises and committing an indictable offence, and 1 count of attempted arson. The prosecution's case rests highly upon the confessions made by my client. These submissions were made during a formal police interview at the police station and on a car travel back from the scene of the school to the police station prior to the formal interview. Now, if you were to admit these into evidence, it would go against the public policy and the 5 factors put down in Bunning and Cross. The 5 factors being the conduct resulted from a genuine mistake or a breach of law. The second, the evidence was gathered due to a genuine mistake. Third, the conduct was a response of pressing circumstances, such as the evidence being destroyed. 4, the gravity of the charge against the accused. And 5, the conduct in getting the evidence breached a statute. Now, in terms of my client, for these 5 factors, for the first factor, there seemed to be no genuine mistake, but rather a breach of law from the police officers attending. It would be debatable as to whether it was deliberate, but it was certainly a breach. There seems to be no genuine mistake in gathering it, as there was a process and a lineal function as to how the confessions were attained. The third factor, yes, my client did try and flee the scene once she was noticed by the police. However, she was quickly apprehended and posed no further threat of the evidence being destroyed. So there was no reason as to why the processes upon the PPRA and the Police Powers and Responsibilities Act could not have been followed. The gravity of the charge is it is an indictable offence. However, it is not consistent with a murder as to how some of these other charges, confessions have been admitted, such as a Queen and Sailor. And the 5th factor, the gaining of the confession breaches the statute. It breaches the statute under the Police Powers and Responsibilities Act and the Police Powers Regulation. Section 420 of the PPRA and Section 421 deal with questioning of a child and questioning of an Aboriginal and Torres Strait Islander, my client being both. With these, there should have been an offering of a support person, which there was, which was inadequate for what my client needed. It was a middle-aged social worker being a white male of non-Indigenous background. The second was that there was no attempt made by the police officers to notify legal aid. My client should have been allowed to have a legal aid representation or a parent or guardian, of which there was no evidence to suggest that they were attempted to be contacted either. In addition to this, Section 25 of the Police Powers Regulations has some procedural requirements when interviewing Aboriginals. These include finding out about their education level and their capability to understand the questions being asked. Now, there is no evidence on the facts tendered in the confessions that there was the question of whether my client understood the questions being asked. She has admitted to me that she just answered the questions. The advice provided to her by her support worker was just answer the questions provided asked by the police. Now, this is evident that the police have failed to follow the correct procedures in providing support under Sections 420 and 421 for an Aboriginal child in attaining a confession during a formal interview. If these were to be allowed, the case of Queen and Sailor shows that the confessions can be admitted. However, the confessions attained and interviews for that case were vastly different to what was conducted for my client, and thusly, in my case, for my client, they should not be allowed to be admitted. The case of Queen and Day also showed that to protect the public interest in the unfair treatment of individuals, it is not to do so would flaunt the law for the officers whose job it is to uphold it. By allowing these confessions into evidence, it would show that the police officers involved were not following their proper powers, and it gives them a leeway to do so in the future. In addition, in providing a support person, there should prove to be no cultural congruence. In the Queen and Day, it outlines some particular matters that can affect Indigenous persons, including the need to have a support from an Indigenous person, long silences during communications, and the legal aid representation. There is a lack of cultural competence in regards to my client and the way that she was dealt with during the interviews. There is apparent gratuitous concurrence in her answers, and it would be debatable as to whether she was really understanding the questions that were being asked. So, on these grounds, I ask that you consider the confessions put forward by the prosecution to be inadmissible for the evidence against my client. Thank you, Your Honour.